Welcome to NeLI, the official podcast of the National eDiscovery Leadership Institute. Hi, I'm Daniel Gold, your co-host and navigator through the evolving landscape of eDiscovery.
And my name is Bridget McCormack. I'm the co-host of our podcast. Our guests, from judges to eDiscovery professionals, share insights that cater to all experience levels.
Whether you're looking for a broad overview or in-depth technical analysis, this podcast is your gateway to understanding and implementing effective eDiscovery practices.
It's important to note the opinions expressed on this podcast are those of the individual guests and the host, and do not necessarily represent the views of their respective employers.
We're here because of our passion for eDiscovery and our commitment to providing free, accessible educational content to legal professionals everywhere. And welcome back to the NeLI, the official podcast of the National eDiscovery Leadership Institute. Today's conversation is one that Brandon and I have been looking forward to for quite some time, because our guest, has been on both sides of a question that our industry doesn't talk enough about. When courts and arbitration systems modernize, who is that modernization actually serving? The litigants? Is it the lawyers, the institution, or some combination of the both? Our guest is the best person to talk about it. Bridget McCormack, President and CEO of the American Arbitration Association, as well as the International Center for Dispute Resolution. Now, before joining the AAA, Bridget served as the Chief Justice of the Michigan Supreme Court, where she led one of probably the most ambitious court modernization efforts really in the country. And that included the rapid scaling of remote processing during the pandemic, civil discovery reforms aimed at proportionality, and also a sustained focus on what she has consistently described as access to justice as a human experience, not a procedural one. A theme that Brandon and I have been hearing a couple of times here on the NeLI podcast. And I think what's going to make this conversation different is going to really be Bridget speaking not from the sidelines, but rather someone who's actually done the work, rebuilt processes, watched them work, and brought that over to where the AAA is today. So, Bridget, welcome to the NeLI Pod. We are so glad that you are here today.
I'm excited to be here, excited for the conversation. Thanks for having me.
Amazing. Well, let's go ahead and really get started here, Bridget. So before we get into everything happening at the AAA right now, I want to go back a bit. Now, you spent nearly a decade on the Michigan Supreme Court and 4 years as Chief Justice. Most people think that that role is purely adjudicative, but you came out of it sounding much more, in my estimation at least, like a system designer more than just a jurist. When did your thinking start shifting from deciding cases to redesigning how the entire court system operated?
Yeah, I don't think there was a time when my thinking changed about the role. I think it's something about the role that very few people understand. State Supreme Courts are charged in most state constitutions with administrative oversight of the courts of their state. And so state Supreme Courts approach that role differently. Some delegate a lot of it to a judicial counsel or a state court administrator and his or her team. Others are rolling up their sleeves and really trying to figure out how to make the state court system work better for the people who need it. The Michigan Supreme Court is in that latter category. It was one of the reasons I was attracted to the job in the first place. I think the decisional part of the job is obviously critical and pretty important to all the rest of it. But the opportunity and the responsibility to figure out how a justice system can serve the people of a state better is a much harder problem and a really, really important problem. So that part of the job actually attracted me to it in the first place.
Well, Bridget, as you looked at that part of the job and as you executed on that part of the job, if you had to grab a handful of things that you think, when you think about the experience of litigants and people who are participating in the justice system, what are the pillars that you say are things that are just sacrosanct? These can't change. This is what it always has to be about, no matter how it's being executed. But we'll talk a lot in this podcast about change around AI and automation and things like that. But as we're looking forward at that change, what would you say are your primary three things about the experience that cannot change for those who are participating?
I have zero things on that list, Brandon. Sorry to disappoint. I think that if you approach an institution as important as a branch of government that is delivering justice to people who need it, and also extracting it from people who need to have it extracted from.
Mhm.
And you think that there are things that can never change, you're going to have a hard time figuring out how to serve the people you're serving. So there may be things that take a long time to change. There may be things that, after due consideration, people like the way we've been doing it for 250 years. But I think if you have anything on a list where you say that can never change, you're going to have a hard time, negotiating a complicated, fast-changing future.
Mhm.
Yeah, a refreshing outlook. In all reality, I mean, especially in right, wrong, or different today's political climate. I mean, just to know that there's nothing that's not on the table for reconsideration, I think is fantastic. And that actually brings me to my next question. So thank you for that great segue. Uh, so your 2020 discovery reform replaced reasonably calculated to lead to admissible evidence with a proportionality standard, essentially following, I think, really with the federal path from 2015, just 5 years later. So for the practitioners who are our listeners to the NeLI Pod podcast, who lived through that federal transition, what did Michigan's experience add to the conversation? And were there things that worked differently in the state level than anyone expected?
I don't think that Michigan is different from any other state, but I do think that there are state level practitioner concerns that are, different than most of the litigation in federal courts, and I think it all comes down to volume. I mean, the state courts are handling just significantly more cases. And whether the particular lawyers are or not, whether a particular law firm or a particular lawyer is handling more cases than her counterpart in federal court isn't really the point. But the courts themselves are just dealing with such high volume that it's harder for a court to focus on the specific hard questions. And that's not only in discovery and e-discovery, it's across the board. But given how rapidly discovery has been changing, and I mean by that, like how much more, information there is that has to be managed in the course of litigation, that it just presents unique challenges to state court judges that I think are true. Not only that's not true only for Michigan, but most state courts.
When you looked at those challenges, speaking specifically, if we narrow our focus to look at discovery, um, volume obviously is one of the issues that you were dealing with on the state court level. What were the other things that you were trying to solve when you started implementing some of the changes that you made around discovery advancement in Michigan?
Yeah, I mean, we kind of went about the process with again with an anything is on the table mindset. So we engaged practitioners who spend most of their time on one side of the V or the other. We engaged professionals in the e-discovery space, and we engaged trial judges who were really struggling with managing the issues before them, to learn from them, like what they thought would work well in Michigan, in our state courts, and whether that was the what the federal courts were moving to or something different. We were completely open to it. But I would say the court in particular had no preconceived notions about what the right answer was. It was really driven by the court users. E-discovery was one place where it was hard to hear from the lawyers' clients. You know what I mean? I actually believe that the people that the court serves are the parties more so than the lawyers, and certainly more so than the judges. And so in lots of court reform issues, we tried to figure out a way to hear from the actual people who are impacted by a process change or a process update. That was harder in eDiscovery. And so we really had to rely on lawyers' representations about what their clients wanted, what their clients cared about, and what was going to, be most beneficial to their clients. And I think it works in that context. If you guys have different ideas about that, I'm interested though. I always want to hear it.
Well, Bridget, the way that you speak about the access to justice is a way that I haven't heard some other folks talk to. It reminds me of when President Clinton was serving as president all those years ago. For those that are old enough to remember when President Clinton served as president, he was doing a special on ABC for children, and all the children asked all the questions. And then at the very end of the program, I remember one of the kids saying, thank you, President Clinton, for being here. And his response was something that obviously it's stayed with me all these years later, which was, thanks for letting us into our house, was how the
Mm.
child said it. And President Clinton said, it's not my house, it's yours.
Yeah.
And I'm like, wow, I mean, just, obviously it stayed with me. And the way that you talk about as well, the Michigan court, about how the court's consumers, the court's customers, the people who are most impacted by it, that's language you don't often hear. And it's refreshing. And I'm wondering, how much did that include the self-represented, all the pro se litigants, when you're talking about these reforms that you're going to make? Did it also include the actual people of Michigan as well, not just the attorneys?
Yeah, maybe more so than attorneys, because as
So
I'm sure
interesting.
you're aware, in state court cases, I think the National Center's most recent statistics have it at 75% or higher. At least one party is not represented by a lawyer.
Mhm.
So most people in state court systems are navigating their civil justice problems, not criminal, but civil justice problems without lawyers. So you have to figure out what works for them, because we're never going to lawyer our way out of that problem. So figuring out what works for people who are trying to figure out how to get a little bit of justice is pretty important. We did a lot of town halls before the live town halls before the pandemic shut us down. We had to move to this platform, to the Zoom platform, when we were launching a Justice for All Commission, because we really needed to understand from the people in the different communities across the state what it was that they wanted and needed from their local justice system, their local court system. Similar process with the jail and pretrial task force, which was actually a multi-branch, multi-stakeholder task force, but I co-chaired it with the lieutenant governor, and we did town halls around the state where we literally heard from people who have been impacted by the jail and pretrial policies. I don't know any other way to do justice system reform than to hear directly from the people who are impacted.
Yeah, that's interesting and amazing the scale of having to do that and the ability to do that and hear from that many people for what had to be pretty rapid change. And one of the things that you mentioned in there was COVID shutting you down and having to move away from some of the forms that you were using. One of the other things of note related to COVID is how quickly Michigan sort of scaled up remote proceedings during COVID when we were forced into sort of different circumstances. As you saw that happen, or as you participated in that happening, did you run into a lot of surprises about how litigants, whether individuals or represented by lawyers, responded to what it was like to no longer be in a courtroom, but to do all of this remotely? And what do you think helped you in future changes that came from that sort of immediate need?
Yeah, in some ways, the pandemic gave us all this data that would have taken us forever to otherwise get in
Mhm.
courts about remote proceedings and who they work for and why. Michigan was lucky. We in December of 2019, we purchased Zoom licenses for every judge in the state, and I wish I could say that's because we were prescient. That's not true. Michigan's just a huge state, and it made sense to us for a lawyer to be able to appear in Traverse City in the morning and Detroit in the afternoon. So it seemed like a good idea. That didn't mean that anybody was using them by March of 2020, but we had the functionality. So we were able to very quickly stand up remote courtrooms around the state and spend our sort of innovation hours and budget on other things. Like we built live streaming for the public to be able to watch those court proceedings, and we threw up a website where the public could literally click on a county and then on the right courtroom and just watch what was happening, and then a million other things from there. But back to what the really important question you asked, and I appreciate it. We ended up collecting a whole bunch of data. Lots of it was just quantitative. Like we knew after some number of months and then some number of years the default rates, especially among self-represented parties when they had a remote option, and they were significantly lower. In retrospect, I like to say, duh, because there's a lot of barriers to getting to a physical courthouse, like transportation. In Michigan, we don't really do public transportation so much. We believe in cars, and cars are expensive, a lot more expensive than a phone. And sick kids, and sick parents, disability. There are lots of reasons why the barriers to getting to a physical courthouse are significant. A new job. I mean, I watched a lot of online proceedings during COVID, and I can't tell you how many times I saw a parent or a criminal defendant who had gotten a new job, but was able to make his court appearance in his break room, and therefore not have a warrant out for his arrest. There was no way he could have gotten a day off from work. But he really wanted to, also make his court appearance, and he was able to do that. And, again, in retrospect, of course, that all seems obvious. But we all of a sudden had data on all of that. In addition to that, we had some qualitative data that is, I think, as valuable. We heard repeatedly from judges who oversaw cases with children as either parties or, impacted, impacted by their parents, decisions. And repeatedly, judges said, I'm getting just higher quality information from kids when I can talk to them in a video context. One judge told me, this one girl would never, she had a very hard time talking in a courtroom, which I understand the courtrooms are scary even for lawyers, right? They're just like scary places. Imagine putting a kid in there and like trying to like have them like tell you something that's hard to talk about. But in her room at home, she wanted to show the judge her artwork and show her homework, and so the judges were getting like better quality information out of certain kinds of people. Legal services lawyers who are limited by being human beings and having to get from, courthouse to courthouse in, say, an eviction like docket, were able to do, I think the Southeast Michigan Legal Services folks said about 7 times more cases when they had the opportunity to appear remotely. So it's, like across the board, win-win to have a remote option for, most proceedings. Obviously, for people who don't want to appear remotely, would prefer to be in court, you have to have that option too. But the idea that knowing what we know now, that you wouldn't offer remote options in almost all cases, it feels pretty user hostile, if you ask me. And I know that many states have gone back to requiring in-person attendance for everything, and Michigan's not one of them. And I think that's a mistake. The courts are for the people; they're not for the judges. For the most part, the people don't even really want the judges. Frankly, they don't want the lawyers either. They want to solve their problems. We are, as Richard Susskind says about the drills, they want holes in the wall. They don't want to buy drills. They have to buy a drill to get holes in the wall. Well, they have to put up with lawyers and judges to solve their problems. They're not really in the market for us.
I mean, that is one heck of an answer. I mean, it's like it's also number one, hard to render me speechless. But that is such a great outlook on the justice system and access to justice, and frankly, why we have a justice system, the way that it was crafted by, the founding people who crafted our Constitution. That's just so interesting. Let me ask you the other side of this. So the other side of this is, and obviously we're going to be talking about AI a bit as well, but when I just heard a stat, and I can't quote the stat, so forgive me, but I heard that because of AI, we have a far more crowded docket system than ever
Yeah.
before because of pro se litigants being out there and filing their motions. And it's everything from like an offense that they had with a credit card company to whatever it might be. And just the volume and the density of the filings by pro se litigants as a result of AI is just increased in magnitude. What's your stance, or how do you feel about what AI is doing to both empower equal justice to the law and access to the law, but simultaneously just hampering the docket system?
So I think the data point you're looking for is a recent paper by an MIT scholar and a USC scholar whose
Yes,
names
thank you.
I'm not
Thank
going
you.
to pull up right now.
Yeah.
They looked at court data, but only federal court data from the change from 2024 to 2025, and that sort of the 20 years before that, the the filings were basically steady. They really didn't change. The self-represented parties filed the same amount, the same number of kind of cases year to year. And in 2025, the increase was maybe 14%. It was significant. Don't quote me on that. I can look it up. But it was a significant jump. It's also the case, by the way, that same paper that the number of pleadings filed by lawyers has significantly increased. Lawyers also are able to use AI to file a whole bunch more motions. Courts are seeing increased filings not only from people who don't have lawyers, but also from lawyers. The most interesting finding in that paper is that the number of cases that were, dismissed for for not being able to state a claim, or were improperly like not shouldn't have been in court at all, remained the same as in those prior years. So even with increased filings, we were seeing that what we know is a lot of those needed to be filed, right? These were like valid claims. Um, my guess is that the state court data is going to look significantly uh, more robust. We're going to see even more increased filings in state courts, because state courts is basically where most people go to get justice. 98% of civil and criminal cases are adjudicated in state courts, not federal courts. And I have anecdotally talked to friends who sit on state Supreme Courts, and my friend Beth Clement, who's the CEO at the National Center for State Courts, and they say that the filings are just off the charts. But if they are cases that need to be there, I think that we should all view this as like a really good news, right? Like a very good news story about AI. Now, does that mean that we need to figure out how to manage all of those disputes? Because it's not like we were managing great before. The courts have been burdened for a few decades now. The courts kind of outgrew the they were designed 250 years ago for a system where every single person had a lawyer, and every matter had plenty of time for a judge to like consider it. That hasn't been true for half a century. And we haven't updated the operating system to respond to it. So yes, it probably means we need to figure out how to update the operating system, but I think it's clearly good news.
When you talk about updating that operating system, do you think that AI on the court side is part of the solution of that updated operating system? And if it is, what kind of questions does that raise? And how do we put boundaries around where and how it's going to be used so that the system gets more efficient, but doesn't start to cut corners?
Yeah, I mean, AI offers incredible opportunities for, more choices for parties that have disputes that need resolving. Of course, those solutions have to be built with transparency, with the ability to be audited for bias and accuracy. Um, and they can be systems that are both assistive to courts, and also in cases where the parties want it, they can supplement, dispute resolution options that courts already provide. And you can imagine lots of areas where parties might prefer that. I mean, we see it in arbitration already. And so I think it's, it's been a long time since we've had a new kind of set of options for resolving disputes, and we now have a technology that can do that. Of course, like the things that people worry about are problems that need to be solved. But we've been pretty patient with those problems in an analog system for a long time. Like if one more person talks to me about hallucinations, and I have to remind them about human hallucinations, including human judicial hallucinations, I'm going to lose my mind. I mean, we have an entire appellate system built to respond to some of the hallucinations that judges make. As you all know, very few of those hallucinations qualify for appellate review, right? We have all these rules about which ones we'll even look at. But we've tolerated human hallucinations forever. We now have a technology that we can require to show its work along the way. If that's what you want, you can require that. You can build in the kinds of, checking that you might want. You can build in the responsibility for the technology to tell the parties how it understands what they think their complaints are. So that there is so much upside potential to building new solutions, and solutions that some parties will want in some cases. I think there will be lots of other cases where parties won't want that. They should be able to have whatever they want.
Speaking of solutions, when your time at as Chief Justice, came to a close, I'm curious about your decision about going to the AAA. What was it about the AAA that was attractive to you, as saying like, this is going to be my next move, as opposed to, being a speaker, writing a book, going on the speaker circuit? I imagine that could have been a great option for you. Well, still is a great option for you. So why the AAA? And then did you walk into the AAA as well? It's a compound question. I apologize. Did you walk into the AAA also thinking like, as a system designer, like here's what I can change walking in the door?
Yeah, I mean, I definitely wasn't. I didn't think I could show up and know what needed changing, if anything. I always show up at a new place and learn a lot before I form thoughts about how I can contribute to where it might go. The AAA was exciting because it's a 100-year-old institution that administers over 500,000 cases every year around the world. So it's really the next largest dispute resolution system once you leave if you leave a state Supreme Court. In Michigan, we resolved, I think, between 3 and 4 million cases a year. The AAA's close, right? It's close. It's more than probably some smaller state court systems. And we have an awful lot of cases where self-represented parties, where parties represent themselves, often on both sides of the V. We have a large self-represented party commercial caseload. And construction caseload. So it really is an opportunity to think about dispute resolution, and also to be able to innovate and take advantage of technology in a way that's harder in a public justice system. I mean, the courts have to rely on another branch of government for their funding. You have to remember that all of the judges across the state are separately elected. And so you might have a new court rule on remote proceedings, and some of them might not think they have to follow it. So it's a much harder change management environment for dispute resolution than a 100-year-old nonprofit that gets to figure out what works and then do more of that, right? If we're doing well, we can, continue to invest in R&D and, build new processes and new services that work. So it's kind of a wonderful opportunity to, take lots of ideas about dispute resolution and build and start building a future at a time when the world was changing, right? I took the job. I started the job in February of 2023, and Sam Altman changed our lives like 2 months before that. So the timing was exciting.
Well, as you look at that, the ways in which you can fold AI into different legal workflows at AAA, you've mentioned a couple of hallmarks already in our discussion, things like transparency and freedom from bias and things like that when you're looking at AI systems. Now, how else do you look at an AI-driven workflow or a potential solution and determine whether this is really going to help improve outcomes, or is it okay that it does nothing but help speed up outcomes and lessen the load?
Yeah, it's a great question. We've been basically building point solutions and then enterprise solutions and then brand new products and services with AI for 3 years now. We armed everybody across the AAA with enterprise licenses to ChatGPT. We took volunteers from our panel of neutrals to arm them with a lot of the legal tools that were on the market. We got them, subscriptions to those. So we could just experiment and figure out what we could build that would either improve our operations, like something that would make what we do internally better, or that would improve the services we provide to the users. Self-represented parties are a big target there because we have a lot of information that is, we think, helpful to them. But when it's like scattered across a website and you are not you're reading these rules and you don't even really understand when they kick in and you have nobody to talk to, that's complicated. And obviously, AI gives you an opportunity to build natural language interfaces across all that information that's really tremendous. I don't know if that explains why we have significantly more self-represented parties filing with us this year than we have ever before, but we do. Another so we basically we took the approach that, like, let's take all ideas. We have an innovation platform that connects everybody across the AAA. We're scattered all over the country, and we have a small team in Singapore. We upload to a shared platform called Bright Idea. And then when a new idea is uploaded, people workshop it. It goes from there into an innovation pipeline, and then we have to do a little bit of, thinking about whether we can afford to build it, whether we have the capacity to build it. And then we built a lot of stuff. Some of those things have been fantastic for users or just internally. Some not, and those we learned just as much from. Like when something didn't work, we were like, oh, okay, so that's not useful for this reason or that reason. That helped us. That helped us figure out, how to place some bigger bets. And the bigger bets are now, either in the wild or about to be in the wild. We released the world's first AI arbitrator in November, which is really a series of agents that operate across the arbitration process. There's, at the front end, a series of agents that take the information from the parties, self-represented or lawyers, take their complaints, their evidence, their any legal support they think that supports their position. And then those agents take everything they have understood and organize it and tell it back to the parties. They come back to the parties and they say, this is my understanding of what your complaints are and what evidence you think supports each element of each claim and what legal support you believe, follows your argument. Did I get it right? And the parties then get to say yes or almost, there's this one thing I want you to add to that, this evidence that you said supports that claim, it also supports this claim. And then the agents incorporate it again and go back to them again and say, okay, here's what I think you're telling me. Do I have it right? Imagine, it's like procedural justice, procedural fairness, on display. And I have to tell you, I did not appreciate that at the front end of the build. I knew that we should build it because I knew that bringing down the time and the cost and bringing up the reliability of an arbitration process for certain parties was important. Was gonna matter. It was gonna make a difference for people to have that option. Again, they should choose. They should have whatever they want. They should pay a human and take a really long time if they want, or they should have that process. I did not appreciate the unbelievable bonus to procedural fairness, which, as you know, there's a robust academic literature about. It's really important in courts. We spend a lot of time, in judicial training because on how important it is to make sure that parties feel heard and understood. There's, the data shows that they are far more likely to accept an adverse outcome to their position. They will take bad news, they will take a loss, and still grow trust in the process if they feel like they were heard and understood. That's really important in courts because today's parties are tomorrow's jurors and tomorrow's witnesses, and we need the public's participation in a public justice system for it to function. And if people lose confidence because their experience is one where they don't believe they were heard or understood, that causes more undermining to the rule of law than anything else I can think of. Well, now we have a magic language calculator, or a series of them that can, literally go back and forth as many times as the parties need to make sure they feel heard and understood before those agents then pass it on to the next set of agents that reason and draft, and then pass it on to a final group where there's a human arbitrator in the mix. We have a human arbitrator in the mix. So those like bigger bets, and we're now training that for other use types. We started with documents only construction cases, and we're building out other use cases and case types on that platform. Those only came because we spent a few years trying to see what we could do, what we were capable of doing ourselves, what we needed to do with a partner, what people wanted, what was gonna be additive to the services we already offered. But I will tell you, this technology is moving so fast that if we talk again in 6 weeks, I promise you I'll have more ideas. We'll have like new things that we know we have to put in the pipeline.
It's so fascinating. This is like a sci-fi movie coming true in some sense. It reminds me of Chris Pratt. He's an actor in a movie called Mercy that came out this year, and he stars as a detective who must prove his innocence to an advanced AI judge who serves as a judge, jury, and executioner, if you will. And he's falsely accused of murdering his wife, and it's a fascinating movie. I watched it, and I
Wow.
was just awestruck about this AI judge. And on the screen was literally all of the evidence. It was video
Yeah.
evidence, it was testimony, it was depositions, everything showed up on the screen. And the judge was like, here's the evidence against you. And so I'm fascinated by that. And as you're talking, and I'm thinking about all these AI agents, which, by the way, Brandon and I use AI every single day, and I'm fascinated by this whole approach. I'm wondering though, because I am also old school and I have paper all over my desk as well. Where do you personally draw the line between useful automation and decisions that still actually must remain fundamentally human?
Yeah. So I'm a little bit of a broken record. I'm going to tell you what I think personally, but I don't think my view should count for a whole lot. I
Actually,
think
I tend to differ. You are the president and CEO of the
I, I
AAA.
no, I think parties who need disputes resolved should be able to choose. I honestly, so but let me answer your question, and then I'll give you all my caveats. I think that cases against the government, so criminal cases where the government is trying to take away someone's liberty, or constitutional civil claims against the government or other civil claims against the government, um, have to have a person who represents the government, making the final decision and looking somebody in the white of their eyes and telling them what that final decision is, that they passed on it and they believe in it. Civil disputes, especially disputes where the parties have drafted a contract about how they resolve their disputes, I'm not sure why it's my business. I think they should have lots more choices than they have today, better choices than they have today, and especially now that we can build better choices with this technology, where you could have, a little bit of an assist from it. I can't imagine in some number of years that anybody would pay human, arbitrators to do some of the like building the timeline, or some of the work that the technology can already do better than humans, and we know that today. And why would you pay humans when the technology could do that? And they might still want to be able to have an argument in front of a human being and have a human being pass on the final, decision. And there might be some parties who say, for all of our supplier disputes, we want those, under some number of dollars in dispute, we think those can go completely to an automated process. I think there'll be other disputes forever where parties will want a human from the beginning to the end. And those won't necessarily be just like bet the company civil cases. There'll also be cases where parties need to have a continuing relationship. So family court, family law cases is like an obvious one. Where there are kids involved, where the parties have to have a continuing relationship, and it really matters that that relationship comes through conflict well. My guess is a human being will continue to be an important part of helping those parties through that conflict. I could be wrong though. Like, again, talk to me in 6 weeks. We'll see what the technology is doing next. Maybe it's better than humans at that, but I doubt it. And there are lots of employment relationships like that as well. There are lots of conflicts in business where the parties have to continue to have a relationship, and a human navigating that with them will probably continue to be important. Having said all of that, I really think it's very main character of me or any judge or arbitrator to say these are the cases that humans have to be involved in. Like, why? I mean, unless I'm a party, then I'll tell you if I want a human involved in it. Otherwise, like, why? If we have ways to give people lots more options to resolve their disputes and they choose the one that works for them, and they get through the dispute and get to the other side in a better way than any other option, why isn't that the right answer? What do the parties want?
Great question. And if I can build on what Daniel was asking, and also your earlier answer, the agentic approach that the AI arbitrator is taking seems to be get high marks in verification and transparency for the entire process. But you did mention at the very end, there's still a human in the loop, a human arbitrator who gets a
Yeah.
chance to look at things,
Yeah.
which I think also lends to the trust factor, that there's still a human somewhere in this who's looking at my case. Are you tracking, or is one of your goals to track how often that human arbitrator may come to a different decision or may see different nuances that aren't being detected by the agents throughout the process? Is that part of
Oh,
sort of building that trust network?
absolutely. Yeah. I mean, that's actually one of the upsides of being able to see the work that the agents produce and then see any changes that a human arbitrator makes. And we did that throughout the design sprints to build the product. We had human arbitrators from our panel in every design sprint giving feedback on the agent's work. So yeah, that's pretty critical. I always say, like, imagine if a human judge had to show her work, had to literally show exactly how she got from this to that to that. I mean, judges don't have time. I don't mean to, this is not a critique of, of judges, but imagine if they had to go back to the parties first and say, here's my understanding of your case. I believe that these are your claims and this is the evidence and this is the way you think the law fits your claims. And, you, party B, this is what I understand to be your claims. I mean, even imagine if judges had to do that, it would be, I mean, again, there's no way they have time for it. But it might be interesting. I mean, I would love to see that, like, if you could give me like a printout of like some judge's brain in a decision that I don't understand, I would love to see that printout. I want to understand it.
This has been such a fascinating conversation. As we close it out, one of the things I've heard you say and twice now is contact me in 6 weeks. We'll see what it looks like. We used to say like, hey, like what are things going to look like when we ask people for an outlook in a year, 3 years, 5 years? I'm with you. I don't think it's 1 year, 3 years, 5 years. I think it is this cycle because we're seeing the magnitude of change that's happening so quickly. So for the AAA, for the justice system as a whole, what is your hope that you are going to see the end result? What is it that the end result is going to look like for you? Like if we're to get to a better place, and your passion clearly is with access to justice, right? Make sure that the people are the consumers of the law. I love how you said that.
Yep.
What does that look like to you? What is end state really going to look like for you that would say, yes, we've gotten there?
Yeah, it's such a good question. So yeah, 6 weeks is about the timeline. I do think, and the reason, I think it's actually, I'm going to do my best to answer your question, but I think our human brains can't do it. We are really good at, well, really good. We're somewhat good at projecting in a linear way. We are not capable of projecting in an exponential way, and we are living in an exponential timeline. And the impacts on the legal profession and the justice system's little corner of that legal profession are coming from, all sides that aren't in our control at all. So the number of filings that we talked about is off the charts. That also means that the access to information is just growing, which is tremendous, frankly. The discovery we're going to see across science and medicine and engineering is so exciting, but it's going to cause all kinds of really important, like, legal questions over the next, weeks, months, and years. We are starting to see agents forming contracts. Agents are forming contracts with other agents, and not just like B2C, B2B. And we have no legal framework for what law governs. And I've given it a lot of thought, and I don't think that the e-commerce law that's grown up for the last 20 years fits. So we have entirely new areas of law that are just going to have to be developed. I think all of that can be overwhelming, but we're moving from a world where legal information and access to it was scarce and therefore guarded by the guild, to a world of abundance where legal information is going to be abundant. That's good. I mean, the idea that we have this public good, the rule of law, that has, that is responsible for the greatest economy in the world, right? And lots of other good things, but is guarded and not accessed by most people, has held us all back. It hasn't been good for communities. It hasn't been good for the economy. And so moving to a world of abundance is, in my view, far and away, there's a lot more good than bad, but it's going to be a little messy along the way to figure out how it all, comes together. But I am, at the end of the day, very optimistic.
This has been one of my favorite conversations that I've had on the NeLI podcast. Thank you so much for joining us today. Thank you for being a part of this very important conversation and letting what I and Brandon believe to be one of the most critical voices that needs to be out there. So thank you very much for joining us.
Yes.
Thanks for having me.
If you've enjoyed our discussion and want to learn more, don't forget to subscribe to our podcast on your favorite streaming platform. We're here to help you stay on top of the latest trends and developments in eDiscovery.
We'd love to hear your thoughts and questions about today's topic. Reach out to us via our social media channels or email us directly. Your feedback makes our program stronger and more attuned to the topics you care about in the world of legal technology.
Remember, all the resources and insights shared today are aimed at enhancing your practice and understanding of eDiscovery.
Join us next time on NeLI Pod as we continue to bring you expert knowledge and lively discussions. Until then, keep innovating, keep discovering, and keep pushing the boundaries of legal technology. Thank you for listening, and we'll see you next time.